Hello, everybody. Welcome to our webinar. My name is Deborah Oppenheimer. Thanks for joining us today. Appreciate it. On your screen, you should see primarily the PowerPoint presentation. You should additionally be seeing a small box on the left-hand side with me. You should also be able to see on the right-hand side of the menu a private chat icon. If you have any questions, go ahead and shoot those to me, and I will try and answer those as they pop up. Sometimes if I'm on a roll, I'll come back to them. So I'll try and keep track of those. If you have audio or video issues during the presentation, click the no audio video button and follow the instructions. One CMCA credit will be automatically generated and emailed to you within about 48 hours after the webinar, assuming you attend the whole thing. We get a list of who checked in and who attended the whole thing, and that's how we generate our CMCA credits. They're not transferable. This will be recorded and added to our Altitude YouTube channel so that if you see something and you think it'll help a board member or another manager, feel free to direct them there. Lastly, at the very end, there is a survey pop-up that you can take, and we really do appreciate any feedback. So please let us know. So we're going to focus on a couple things today. We're going to focus on nuisance type violations and how the statute of limitations plays into it, and how HB 1137 plays into it. As you know, obviously, we always have all kinds of other information on our website, our blogs, our newsletter. We all are, I'm sure, been waiting to see what the is going to come out as new legislation. There's stuff that's been voted that hasn't been signed yet. You can always check and see what the status of any of the bills are, where they're going. That's also on the website. So feel free to jump in and take a look at that. So let's kind of think through some of the things that are nuisance type violations. And again, the primary focus on most of these issues and how they kind of affect us and why they're so difficult is because they're short in term, right? They're short in duration. So there are things like, and there are also things that you can't necessarily get a picture of, right? How do we prove it in court? How do we enforce this so that we can take it and actually help our homeowners and stop some of the problems we're seeing? And so the things that are going to pop up are things that are difficult for a variety of reasons. So we think about loud parties, loud TVs, screaming, fighting, animals that are barking, that are howling. One of the ones that frequently pops up is police getting called out constantly. Smells. This one has its own weirdness, right? Because what if you're somebody who's super sensitive and you smell it before anybody else does, right? Does that mean you have to just put up with it? Does it mean you have to take steps? And is that unfair because you have a super sniffer? But these are things that we encounter as managers, as attorneys trying to work through these problems. But we see smoke, whether it's cigarette or marijuana, often doesn't matter anymore. It's just smoke. Cooking smells, body odor, paint smells. We see a bunch of the paint smells coming up with homeowners who are those super sensitive types, right? I can't take the smell. If you're going to put new paint in or if you're going to put new carpet in, it's going to upset me. You have to do something. These are issues that all pop up as somewhat of a nuisance type of issue, right? Trash on the property. Most of the time the complaints are that they put it out too early, they didn't put it away to when they're done, or you have some homeowners who just leave it there forever, right? The ones who leave it there forever are actually the easier for us to deal with than the ones who just leave it there for a day or two and tick off all their neighbors. Each of these, dogs off leash, not being picked up, parking issues, pool violations, short-term rentals. Because it's short-term, it's going to be a day or two, right? It's not going to hit any of those long-term categories. It's because they're so short in duration that they become a problem because of HB 1137, right? One of the other problems that, as a manager and as an attorney we run into is how subjective the complaint is, right? For those of you who are old enough to have gray hair like me, you'll think about the Mrs. Kravitz of the world. She watched everything and she reported on everything and she talked about everything and everything was a problem and not correct. Is that who we have living there that's issuing you an email every day? Is it 4 people who are all right there together and only one person is ever the person who calls it in? Or is it you have 4 people living there and 3 of the 4 drive off to work every day, and so there's only one person who sees it, right? That makes a big difference, and we need to evaluate that when it comes to court. And sometimes we have to think really carefully, how do we politely tell the person that while we appreciate, she saw this, it's not a problem. Obviously, you also have to contemplate, what should a multifamily housing owner expect, right? Do they have, is the problem that, they're just not used to living with lots of noises? I worried about that a lot when my father moved out of a single family house he'd had for 70 years and moved into, a house with neighbors. He never had to listen to any water in the, halls. You never, you live in an apartment, you get to hear your neighbors flush sometimes, depending on how thin the walls are. And that's something that we need to contemplate, because realistically, that becomes a proof problem when we walk into the courtroom. If those walls are so thin that that's what you can hear, some of the things that are going to be complained about aren't things that the court's going to care about, right? The specificity of the governing documents sometimes can go really bad for us or really good for us. And when they say anything that annoys you, well, okay, what if you're, the grump, right? You're the guy who sits there and everything annoys you. Nothing is right. Is that really a nuisance that you have to jump in and you have to take care of, right? We have to keep that in mind. So when you're looking at the things, the first thing that you've got to look for is, what do you have in your documents? And, one of the things I frequently see is I see something where a homeowner just assumes, well, that can't be allowed. And when you ask them to point to the rule or the declaration, they can't, right? They can't. Because I remember a community, huge community, over 3,000 homes, older documents, old enough that they presumed homeowners would maintain their property. Nowhere in the governing document did it say homeowners have to paint on a routine basis. Nowhere, okay? But homeowners presume, right? They presume that, in fact, there is something going on, right? And it may not be there. So we got to start there. Always got to start there. The other thing you need to think about is there somewhere else we can push it? Because with HB 1137, we have really got to look for the external help. This is a situation where, on sound violations, almost every city and even the counties have noise disturbance. Either there's a statute, there's an ordinance, there is something out there that says, you can't make too much noise. And we have to look for those, because our hands are going to be tied so often. We are going to be looking for external help. Code enforcement is, on trash issues, we have got to look for the external components to help us, because otherwise, all you're going to say all day is, I can't do anything because it's too short in term. And that's not going to make anybody happy. And then you get people riled up and screaming at your board meetings, which none of you want. What about if there isn't anything? Should we think about adding a rule, right? Do we want to craft something that can help us? And in some circumstances, I'm going to tell you yes. And in other circumstances, I'm going to tell you no. So if it's on the common property, it's on the parking lot that the HOA owns, and we're trying to put some rules in place, that's fine if we can actually enforce it, right? So if you've got a parking lot and you've got problems because of how they're parking, and there's nothing really in your documents to help you, by all means, call whoever counsel is and work with them to help create maybe a permit process for your parking lot, right? Some rules in place that then will eventually lead to towing. Because we all know with 1137, Parking isn't a safety hazard, so it's not a 3-day rule, it's a 30-day rule. And we don't want to wait 30 days to deal with that car. So we need to think outside the box, and we need to think about the fact that if in fact we've got a problem, can we create a rule and can we use other methods, right? And sometimes it might be you're going to contact council and they're going to say, wait, we can't even just do a rule, we're going to have to do an amendment. But if your homeowners are really up in arms about it, they're going to help you. You're going to get what you need, which is, let's get that rule, let's get that amendment, let's deal with the parking so that everybody, it's easier on everybody. When you really don't want to think about adding a rule is because it's one violator, right? You never want to create a rule for one person. It's not going to end well. It's going to look like you're selectively enforcing against them. It's not going to look fair. Nobody else is doing it. Why did the board all of a sudden create a rule that really only applies to one person? It's not something you ever want to do. Actions inside a unit, inside a garage, you cannot do that unless it's in the declaration. So you can't create a rule to deal with internal issues. That's going to have to be an amendment, okay? But let's say you do have a rule that says no short-term rentals, right? But we're going, well, how do we apply that? How do we make that work, right? They're there and gone in 3 days. How do I comply with 1137 and still deal with that? That's one of those that we're going to talk about. There's a rule you can add to help you to enforce what's already there. It's already in the covenants, and we're going to try and use that to help us with adding a rule to help you enforce it, okay? So this is, some of the void or some of the very vague language that we use to look at, right? Unreasonable annoyances, right? Any conduct in the board's reasonable discretion creates a danger or a risk, right? That's fairly good because it gives you some control. But how often do we open up our declarations for our communities and we look at a nuisance provision that says unreasonable annoyance to the neighbor? And so you get that call and you get that complaint. I had one from a manager a couple weeks ago complaining about what was said in the sign in the front yard. And we all know that the statute says we can't control that. But that's an annoyance to me. You should do something. And then you have to explain how the statute took that away from us and we have no ability to deal with it. And so, when we're looking at that, we have to remember that we're going to have to think differently. I've been doing this over 20 years, and some of our tried and true methods we're having to tweak because we have to think about this in a different method, right? In a different methodology. When we're looking at the statute, right, we're trying to think public safety or health, no threat to public safety or health, right? Most of our nuisance violations are going to be the no threat to public safety. Very few of these are going to pop up as a threat to public safety. And because of that, we're looking at that 30-day cure before we can even get to a fine, for heaven's sakes, right? We're just not seeing it. And so because of that, that makes each of these quite a bit different. And that's why a lot of the things that I'm going to direct you on are these kind of 4 options, because these are the ones that we're going to have to rely upon in different formats, but these are what we're going to have to rely upon. And we're going to go through each of them kind of a little bit at a time, but we're going to focus a lot on these. And again, it's not, I've got on the slide police, but it's not just the police, right? It's police, it's code enforcement, it's animal control, it's the health department, it's the fire department, right? We're not limited to just the police, but just think external means, because we've got to use outside the box, outside the norm, because otherwise a lot of these we're never going to get to. Then they're just you're going to send a lot of first letters and never do any more. So, okay, starting with noise. Obviously with the loud parties, most of those happen after all of us are done. It's going on maybe your emergency line, if they want to call it an emergency line. But you've got to tell them they've got to call the police. There's just no ability for you to deal with that in any way when you have 1137 requiring 30 days. A loud TV. That one you might want to think about who the person is and why is the TV loud. Is it my dad who's going deaf because he's 95, right? So what do we need to do with him? We need to see if in fact we can go find some of those earphones, right? You don't have to go as far as a hearing aid. They have those really helper type things to make it so people can hear. They use them if you ever go to the jury. In the jury box, you get somebody who has hearing problems. And we can maybe help the neighbors and help the homeowner and get everybody, at an easier spot. And it's not a huge expense, right? Think outside the box. Do you want to spin your wheels for having this call come in day after day after day, right? And always wonder, well, does he leave the TV on forever? And so maybe I will get to 30 days. Or is it sporadic and I've got to think outside the box? And is it cheaper to go buy him a pair of headsets that he can listen to his TV and he can hear it and the neighbors don't have to, right? Sometimes you got to think outside the box because we're not going to get there the normal way. And we still have to try and help our homeowners enjoy their homes, right? Okay, how about the, screaming from the neighbors and the fighting? One of the things that I've been getting a lot of calls on is how do we stop the tenants that are screaming, fighting, and the cops are constantly being called to their house, right? There's not a ton of good answers for that one. Again, if the neighbors call you and say, look, the cops are always being called, get the address. I will tell you, as a manager, as a neighbor, anybody can go and get the police reports. They may redact names, especially if there's juveniles in the home, but you get that police report. Take that police report, especially if they're tenants, fire it off to the landlord. Let him know that, in fact, there is constantly fighting, screaming, yelling, cops getting called, because he's not going to want to continue that. Again, most landlords want a constant tenant who's just going to pay the bills. And people who are getting the cops called on them constantly don't often stay there as much as possible. And so there's some risk there. So let's use what we can. Just contacting the landlord without the police report will probably get you, well, how do I know that's true? How do I know the neighbor doesn't just like them, right? So get that police report, fire it off, right? Go ahead and send the violation letters to them for the screaming, the yelling matches. However, realistically, if they keep paying their rent, you're not going to have a good answer, right? We're not going to have a 30-day event here. We're not going to have, they had a screaming match every 30 days. If you know anything about domestic violence, it doesn't work that way. There is a cycle, and you go through the screaming, yelling, hitting. Then there's an intervention maybe from the cops, and then there's the lovey-dovey phase, and then they get back to it, and there's just this cycle, and that's why it's called the cycle of violence. You're not going to have a 30-day period, so you're never going to get to fine stage on your own. You got to hope that the landlord's going to do something. If it's an owner, all you're going to do is send a lot of first warning letters. There's not much else you can do with that one. I'm sorry to say. Now, I can tell you that the neighbors who are putting up with that might have a cause of action to sue. The HOA does not, but the neighbors might, because there is what's called in Colorado the right of quiet enjoyment of your homes, right? You have that and you can sue on it. I've seen that successfully done neighbor to neighbor, where the neighbor sued because the other neighbor was constantly having problems, right? There's constantly something going on. And so you had this situation where HOA didn't have any cause of action. We couldn't get to it, but the neighbor could, and they did file suit for lack of, loss of the right of quiet enjoyment in their home, right? So, all you can do for the non-screaming owner is tell them to call the cops. Use the police reports if it's a tenant, send it to the tenants. Let me back up a bit. Other way. Also on the barking, howling, call animal control. The reason most homeowners don't want to deal with animal control is they have to sign their name, so the neighbor knows who did it. And often it requires 2 signatures, right? 2 neighbors to sign and complain about it. Again, push back on your homeowners complaining and say, look, I don't have any ability to do something. HB 1137 has tied my hands. If you want this to stop, you need to make the complaint. That's the only option we have, and push it right back on them. That's what they're going to have to do. Remember, when homeowners tell you that you have to violate somebody for the cops being called to the house, okay? You have to remember something. One, we all have the right to call the police, and you have no idea when that cop car showed up at that house, who called. It could be the owner of the house calling to say they're being assaulted. They have a right to make that call. It's not a violation for them to make that call. They just got assaulted, right? It could be somebody's breaking into their house. They're calling. Your covenants, most of the time when they do have a covenant about it, says violations in the community, a violation of law is a violation of the covenants. Just because a cop showed up at that door does not mean whatever the violation was happened there, and or the person who called the cops is a victim. So just because cops show up does not mean we have a right to send them a violation notice. You have to know that. You have to let your homeowners know that. There's may not be anything we can do. But, you know, again, call the cops. That's going to be something that is going to be one of the biggest things we're going to say. And when it happens again and again, and I can't get it to stop because they're an owner, your answer is going to be, you, Mr. Neighbor, have a right of action against your neighbor, but I don't. So, you know, you need to kind of be aware of that one. The other thing that you want to think about is kind of some of these that the short term, we're going to look, we used to use short-term issues on hardwood floors. Let me back up. With hardwood floors, if they're there more than 30 days, right, we can send a violation letter. So if you get neighbors upstairs, downstairs, they start hearing those floors, absolutely, you know, you want to send that violation letter because we're going to hit that 30 days because they put it in, it's going to be there forever, right? That's great, but if they miss it, maybe you have my dad living underneath the hardwood floors and he didn't hear anything. So he never heard the hardwood floors going in. We're beyond statute of limitations. In that situation, we used to tell the HOAs, well, okay, do it on a noise, right? The constant noise as the nuisance, because we missed the hardwood floors. They're no longer something we can attack. We're going to use our nuisance provision to go after the noise upstairs. Well, in this circumstance, we're back to the same problem, only this noise is not something you can call the cops on. This is one that you're going to have to hopefully get the two neighbors together talking and maybe going through the, you know, dispute resolution, right? Because one of those things is that you can get there, right? You might be able to get them to sit down. You might be able to get the upstairs person to put in some rugs. Maybe some areas of the upstairs are tile and they're louder. Maybe some areas of the flooring is something that they can easily put a rug in and that'll soften it to the downstairs. But in this circumstance, you really hope you catch it going in, because if you don't catch it going in under the nuisance that's left, which is when you miss the hardwood floor for not being approved, then you want to move on to trying to get that neighbor to neighbor. One of the questions I have is, when does a dispute resolution trump the violation? And that's going to be almost completely driven by your documents, right? Some documents state, look, if there's a violation and there's the owner who's complaining has to go through this dispute resolution and they have to file something, and if they don't file something and 30 days passes, it's waived, or everything must go through dispute resolution. That's going to be completely dependent upon the documents, what the documents state, okay? And so that's not one that is necessarily going to trump unless your documents say they trump. Obviously, we always have to think about the competing interests, right? We hear more and more of people putting in hardwood floors because of allergies. Like you see me, you know, I have the runny nose because summer is here and things are growing. And so a lot of people are putting in those hardwood floors or wanting hardwood floors because of their allergies. But obviously we know that downstairs is going to complain once it is. You know, a lot of times we can meet, if you get some cooperation. Hardwood floors can be quiet. It's how much sound deadening, you know, is between the hardwood and the you know, subfloor. But if you get deadening, you know, layers in there, they don't have to be annoying and a nuisance, but that takes cooperation. And so using that dispute resolution and reaching out to your parties, that might be something you can do. Again, sometimes we're seeing them where it's a reasonable accommodation to a disability, right? It's not just allergies. It's to the point, you know, they may be in a wheelchair. They have to have it because They can't, roll across a carpeted floor, and so they have to have the hardwood floors. You had to let them put it in. But even when you do an accommodation for someone like that, you can require soundproofing, right? Ask them to get the soundproofing, work with them to try and make it so that, you can deal with the competing interests of the owners. Okay, let's talk about smells. I had a question. What about a fire pit? Is that a smoke as an annoyance? Again, that one is really bizarre. It's like anytime somebody's smoking outdoors. If you walk outdoors, I don't know where the smoke's going to go. And I have, there's no law prohibiting me from stepping outside and smoking. And most of our HOAs, even, HOAs that have no smoking, it's in the building. Outside, there's no ability for us to enforce that. I mean, it might be an annoyance. It might be a neighbor who every night comes home and fires up the wood pit and, uses any wood he can find, and some of that stinks to high heaven, and it really is an annoyance. At some point, you may want to push the limit, right? Tell your board, look, we really need to send this guy a letter. He does this every night. We're going to say he hits 30 days because he's done it 30 days in a row. Push back against the homeowner. The question is he pushes back against you and says, I'm not paying a fine because the fire went out at, midnight each night, therefore it didn't continue for 30 days, therefore I'm not paying a fine. And then your board has to decide if they want to test that in court. Because right now we don't have any other options on that one, right? We just don't have it. When we're talking smoke, when we're talking cigarette, it doesn't really matter if it's cigarette or marijuana. They're both allowed in the home. They're both legal. If your community, even if your community has said no smoking, none, right? So each event is a separate defined event. We know they do it every day. I've never met a smoker who could, just, go cold turkey for a day and then come back another day. So we know it's happening every day. But again, that's a test case to the court. They smoked every single day in the house. They never stopped. And, see if the court will agree with us that that is a violation that is finable, or if the court's going to go, well, unless they smoke nonstop, 24 hours a day, they do stop. And we just don't know what the court's going to do with that. Nobody's tested it. Nobody wants to test it. And until that happens, there's nothing we can do. On smoke, cigarette or marijuana, you might actually meet the safety, health and safety violation, right? Secondhand smoke is clearly unsafe. So can we go with 3 days? Sure. I'm not sure that got us any closer because we're still not going to have somebody who's going to smoke 24 hours a day for 3 days. So are we still going to have that problem of, is the court going to say it was stopped? And there's no way for us to know that. Nobody's wanted to test it. We just don't know. In circumstances for all of these, the smoke, the cooking smells, you're going to have to, again, think about small costs, big safety, right? Or big savings, of basically your time and lack of, losing your mind over these things, which is convince the people who are smoking to get smokeless ashtrays. Work with the neighbors who the smoke is going through their house and make sure that they caulk around all of the air holes, right? So around every outlet, every light switch, every place there's any protrusion into the gypsum wall, right? They make sure that they block it so that both sides take effort to deal with it. It may be the only way we can deal with those because we're never going to get the 30 days. We're not. It's just not going to happen. Body odor uncleanliness is generally somebody who's hoarding, and that's generally going to last more than 30 days. And so that one's actually one of the easier ones until you can follow your normal process and get to a fine stage. And eventually you may end up in court, or you may be able to turn it over to the fire marshal for hoarding because that's one that is going to last. On the paint and the new carpet, that's one that you need to be aware of. You need to if you have a homeowner who says they're super sensitive, you need to try and cooperate and work with them. A lot of them are going to demand that you take extra actions, and that's generally without any legal support. Just because you're going to paint the walls, most courts are going to require you to probably give them advance notice if you know, and most of the time you guys do that anyway. I mean, you don't want anybody touching the wall, so you're going to give them all advance notice. We're going to be painting. We're going to do this. We're going to do that. And so they're going to know these things are happening in advance, and they can take whatever steps they need for their health. If that means they need to go get a hotel room, they can go get one. That does not become your problem simply because they have a medical condition, right? Your advance notice is what you need to give them. So the other thing on, the body odor, the hoarder, again, that's really going back to the external agencies, because a lot of times hoarding is one of those where you're going to have a mental health situation where you want Department of Human Services, or you have a fire hazard and you want the fire marshal. And those are going to be the agencies that are going to help you deal with that. At what point is health and safety versus a normal violation? Again, I've had board members who really want me to agree with them that dog poop is a health and safety violation. And I can't get there if it's in their backyard, right? I can get there if, in fact, it is a place where, say I'm in a single family home and my neighbor brings their dog over to take a dump each morning in my yard. If I had small children, that is a health and safety violation, right? Because dog waste is a health concern around small children, right? And if the kids go out in the front yard, I could argue that time dog poop is a health and safety violation. So it's a 72-hour versus 30. And then there's plenty of stuff on the internet if you need to find it. If you can't find it, let me know and I can help you with that. But it's really easy to go out there and type, and it'll tell you all the different health hazards with dog waste. But the problem with that is you still have to get it there. It's still going to be 72 hours. So you're going to either have to leave the poop there, right? They haven't picked it up for 72 hours. You have to give them the notice it didn't happen. And then you can go after finding them and try and do something at that point. That's, of course, if you know whose dog it is and the person actually lives in your community. On the marijuana smells, the other thing with that one is if that smell, I've had situations where it was a safety concern and an issue on the marijuana issue simply because we had neighbors who worked for DOD and they were going to lose their clearance if they had went and did a urine test. It didn't pass because the neighbor smoked so much pot that it was going through the walls. Sometimes we can push the limits on that one too. Again, it's not truly safety, but I think it's a concern that's close enough we can kind of push it. And definitely, there are secondhand smoke issues and there are safety issues for smoking marijuana. So again, we can kind of push some of it sometimes, but it's also going to require that one that people work together, right? Moving on and thinking about, when some of these violations, are they trash or are they health and safety? Are they not? Obviously trash in the cans that they're not putting away. There's just not much you can do with that one. One of the solutions I had in a very small community that we actually came to a good solution on the trash can that we had homeowners who wouldn't put out is we went to the trash company, and for an extra fee, they would return the trash cans all the way up to the front, sidewalk. And so we actually were able to use the documents to bill the extra fee to the owner who refused to remove their trash cans, right? And we were able to get the trash cans from sitting on the sidewalk constantly because they would just leave them there. Okay, so is that worth it? I don't know. It depends on your community. It worked for this community and it got their attention and it was an extra bill and they didn't like it. And so that became something that we use because, again, that's what we have to do is think outside the box. Same thing with dogs, right? Dogs off leash, dogs not, the owner's not picking up the poop. Those are issues that are quick in time. We're never going to hit 72 hours. We're never going to hit 30 days. It's not going to happen. So what do you do with it? Well, off leash is generally, for most jurisdictions, an ordinance. So you're going to have to call the cops. You're going to have to call animal control. The good news is most people walk their dogs the same time every day, so you might be able to line up animal control to come catch the guy who lets the dog out every morning at 8. That might be something you can work with. You can call the outside agency, get them to come help you on the off leash. On the not picking up poop, some of the out-of-the-box methods that we've been tasked and what we've had come up that seem to be useful is when the people have dogs in the community, We have a registration fee, and the fee is used to hire a company to come pick up the poop. It's thinking outside the box, because we can't get to fine, we can't get to anything else. We can't sue them. You can't even turn it over to counsel, because you can't get the 30 days, much less 60. So you got to think outside the box. How do we do it? They're doing something that creates a common expense to the community. Well, if you can figure out who's doing it and hiring a poop company to come pick up just that one owner's poop, and you're in a post-Kiowa community, there is a provision that says misconduct by an owner that is an expense to the community can be charged back to the owner, right? Can you limit it to just that owner? Can you prove it's just this guy and he constantly does it there? Hire the poop company, bill it, right? Self-help and utilizing Kiowa and some of the provisions we already have. It's a way to go. Now, we're not always going to be there, and we've got a lot of communities that aren't post-Kiowa that can't do that, but we've really got to think outside the box, because we're not going to get to the regular fines. We're not going to be able to go to court. On a bite, that one's a clear health and safety issue, but understand something. If you send a letter to a homeowner, your dog bit somebody in the community, our covenants don't allow for violent dogs, get the dog out of the community immediately, 3 days. We're going to start fining you. You cannot then fine that person for 2 months, 3 months, 4 months, and never take any other steps. Okay, if it's truly a health and safety, it's truly you're worried this dog's going to bite somebody else, you cannot leave the dog there. You have to escalate it to court. You have to sue him and demand the dog be removed. If you do not do that, you can't continue to fine. You can't enforce the fines. You're not going to be able to take any action. Okay, so know that if you say it's health and safety, then you should be concerned enough to take action. You can't say, oh, I want to have a 3-day limit, so I'm going to say it's health and safety, but then you don't do anything. Well, you just proved it wasn't really health and safety if you don't care enough to follow up. Okay, so make sure that when you say it's health and safety, it is health and safety. Backing up to the hardwood floor, I had a question. Can we ask the homeowner to prove that they installed underlayment? Only if they submitted for it and your plan said it's approved subject to underlayment being installed, then you can say, prove to me you installed it. Otherwise, it's a violation of the approval you got. Can we use photos submitted by other residents of pet waste in enclosed backyard areas? Well, you can always use photos from other residents. If they want to go in their backyard and take photos, you can always use those for your proof, but you're on a 30-day period at that one, right? So your photos are going to have to be from the neighbor every day, right? Showing the poop's not moving. And it's going to be every day for 31 days if you want to find them. Because again, it's not health safety in their own backyard. If they want to walk along among the dog poop, that's their call, right? That's not something you get to go a 72-hour one. If you're talking it's in the neighbor's backyard, it's a 30-day. Okay. Would it be okay to reach out to an owner outside of a violation to try and deal with the situation? Again, sometimes, you can email, and I don't really recommend phone calls because you have no way of proving you did this. You tried it, right? But I don't have a problem with emails. I think emails can be really useful in that respect to try and make it less intimidating by a standard letter, trying to work with them, trying to explain why it's a problem and understand you need to explain why it's a problem to more than just that person, right? I know you think it's just your backyard, but do you know the smell downwind from that dog poop? Or do you know that, your wood pile is causing asthma attacks by the neighbor next door? You really are having an effect on other people that you probably aren't intending to have. And I think that's a fine email, right? What you want to be really careful is, one, never promise anything. You don't promise, we're going to get this, or we'll fix it. Okay, you can't fix it. Please work with us. Great. Please come talk to the board. Great. Please come talk and sit down with the neighbor so we can figure out a way that everybody gets to enjoy their backyards. Great. Suggesting we can work on it. We're going to get to a great, way to handle something, yes, let's all work on this. Promising it's going to fix it? No. Don't ever promise we can fix it. Never promise we'll get it resolved. We'll work towards it. We'll do our best. We'll try. Let's see if we can find a way to make this happen, right? That's all workable solutions. But you got to make sure you're not promising anything. Okay, so let's talk about parking. Obviously, that's a huge problem. And the main reason it's such a huge problem is we have so many counties and so many cities that approve a house and and they approve the builder to build something with 1.2 parking spaces per unit. And we all know everybody's got 2 or 3 cars per unit, and you have 1 space, 1.2 spaces. So you don't have enough spaces. So it's a constant fight. How are you going to deal with this, right? Absolutely, you want to sit down with your counsel, because I can't give you any specifics without looking at the document, looking what's around, giving you ideas. You want to try and figure out a way to most equitably distribute the spaces, but equitably in a way that's enforceable, right? I've seen people go, well, can we say they can only park for 10 hours? Are you going to hire a parking guy who's going to, chalk it and mark it and figure out how much time's there? Don't put things in a rule that nobody can enforce. It makes no sense. So when you try and think about how do we set up parking to make it work, we want to think about, one, what's equitable to everybody. We got a whole community. We're not focusing on one person. We got to focus on everybody, and we have to focus on what's available, right? Are we backed up to, a Walmart where they can put their extra cars over there? Are we backed up to a park and there's parking along the streets behind us that they can use? Great, wonderful. We got to remember what we can do and what we can enforce, because you don't want to create a rule that's not enforceable. That won't help you. Okay, what about pool violations, right? Pool violations, actually, a lot of your communities have the ability to use some self-help here. And that's what you're going to have to do, because we're never going to have a 30-day event when something happened that's pool. So what you need to do is work with your attorney, whoever that is, and say, look, I need pool rules that say violations may result in immediate suspensions. Now understand that has to be in the deck that you have that authority to do that. You can't suspend somebody's pool use in a rule if it's not in the declaration to begin with, right? So you've got to have that declaration authority that there can be suspension for violations of the covenants. If you have that right to suspend, use of recreational facilities for violations, then draft up your pool rules and say, you get somebody who is doing whatever it is, it's a violation of your pool, you're going to lose your use privileges, right? That will stop it faster than any of the fines, right? Stop their use privileges and you can get some control, because we're not going to get to fines on pool violations. It's just not going to happen. Do we need a policy or verbiage in the rules to initiate requiring registration of pets or billing back to homeowners for dog waste expenses? So one, if your community wants to think about billing back to your dog waste expenses, those communities are going to have to be post-Kiowa. If you're going to do that, I think it's awesome to send out the notice in a policy, because it's going to put them all on notice. Hey guys, we've been having this problem for years. We're struggling for years. We found this law. This law says we can charge it back. So here's what we're doing. We catch you not picking up after your dog. We're going to hire the poop company to come in. They're going to clean it up and they're going to bill you. We're putting it on your ledger. Here's the statute that lets us do it. It puts them all on notice. One, when the policy goes out, you'll probably have pretty good behavior for a little bit. Then, you'll go back to them not complying, and then you can start billing them. If they're pre-Kiowa, you're going to have to think of something else. Pool rules in the rules and regulation count. I don't understand what you mean by that. Pool rules are not sufficient to give you authority to suspend use. Suspension of use has to be in the declaration. Then you put in your pool rules that if they violate the pool rules, we're going to kick you out. Yes. How about sorry, I'd be smarter than I have to. Can you remove pool access for homeowners who have short-term rental patrons that violate the rules? You're going to have to look to your documents. So most of your documents say, not most, a fair amount will have a provision that says if you rent out your property, your tenant has the right to use the common elements instead of you, the owner, right? Because what you don't want is the owner using them and your tenant using them. So most times there's some sort of verbiage somewhere in your documents that are going to say that happens. And also most of the time in your documents, you're going to have statements talking about, especially if there's tenants, that tenants have to comply with covenants. So if you have covenants that say you can suspend use, and you have short-term renters who come to the pool and violate the rules, you can kick them out. The problem is they were probably only going to be there for a day or two, and the next tenants may also violate it. You can't stop the second tenant because the first tenant was a jerk. And you can't take all suspension simply because one person violated, right? So if you get an owner and you allow rentals, and the rentals are, let's say your rentals are okay as long as they're over a month. And so the owner rents it to party A, and party A's kids are constantly screaming and they get kicked out of the pool. Okay, you can keep them out for however long your documents, your rules say you can keep them out. And you're gonna have to look to your governing documents. Some say there's a limit on how long you can suspend that. Some say don't make any comments. So again, you need to look to your rules, make sure your rules are clear about what you've got and how you're gonna do that. But when B moves in, because they're the next group of tenants in that same, and they again did it for 30 days, you can't kick out B because A was bad, right? You can't say for the homeowner, you no longer ever get to use the pool. That's going to exceed that thing, okay? Beth, you wanted me to go over the bite, and I don't know what you had a question on. If you give me more specifics, I'll try and give you a better answer, but that's not enough information for me to just go over the bite. Okay, so what do you do when you have a house like this? God forbid this was in a covenant community, but obviously aside from the paint, where, we're gonna have to deal with the fact, and that's an easy one because it's well beyond 30 days, but let's look at the trash everywhere, right? They have crap everywhere. And if you look at the stuff that's everywhere, it's stuff that moves. And so the question then becomes, okay, you see on the far, right, there's a red kind of lawn tractor. If he parks it there today, but he parks it over by the tree tomorrow, is it still the same offense? And I'm going to argue yes. And the reason I'm going to argue yes is I had a homeowner who did this. And every day he just moved stuff around, but it never left, it never got put away. It was constant and continuous. And the fact that he moved it, 5 feet, was not cleaning it up, was not moving it, was not curing the violation. It was still not properly placed, and it's still a violation. So my argument is, if you have somebody who does this and it sits there, even if it's in different places, if it's still there for 30 days, it's a violation, and I'm going to say you can fine him. And I say that because I took it all the way through trial in Boulder, and the judge agreed, which is just moving it around. You're not putting it away. You're not curing the violation. You're just moving it. It's in a different spot from A to B, but it's still the violation. It's still the same violation. And so in that respect, when you have that movement of junk, I think it's the same violation every day, non-cured for 30 days. The trash cans at the front, obviously, that's one of those things that you're going to have to give them 30 days to move it. If they move it the 29th day, you're going to have to start over. There's just not much you can do with that one. There's not a lot of self-help there. Okay, as I said with dogs, the messes they leave, you're going to have to kind of look to it. The other problem you can have is I talked about the self-help, but the other thing you might think about on dogs is most cities have ordinances, again, for not picking up after their poop. And with so many of our homeowners nowadays having Ring cameras, a lot of our communities have cameras in the common areas. If you've got a photo, you can show who it is, you can say who it is, you've got the proof. take it to animal control, see if you can get animal control involved and see if you can get them to help you find them. Because again, we're trying to deal with it to the fact that it's not something we can get to find stage. So, you know, you're going to have to think outside the box and utilize anybody you can to help you. You know, policies and rules and regs are the equivalent when you hit court. The title really doesn't matter. You can call it a policy, you can call it a resolution, you can call it a rule. As far as court is concerned, those are all one and the same. They're adopted by a board, and as long as they're properly adopted, they're properly sent out to all the homeowners, so all the homeowners know it. It's one and the same, whether you call it a policy or whether you call it a rule. Yes, if there's a dog bite and you want to cite him and say, get him out of the community, he's a risk to the community, you've got to follow through. Do not send out a demand to remove the dog and then just fine ad nauseum. That will not be upheld in the courtroom. Remember that even if they claim it is an ESA, it's an emotional support animal, it is a service animal, trust me, it won't be a service animal if it's aggressive. They're too well trained. But if it's a fake service animal or it's an ESA, they are aggressive and they cannot be kept, right? Fair Housing Act says that you are not required to allow an aggressive, violent animal stay on your property simply because it's a service animal. That is not reasonable. That's not a reasonable request to you, the community. And so even if it's aggressive, FHA won't make you keep him. So if it's aggressive, you can make them get rid of them. Does a safety issue that has existed longer than a year without complaint, but it's only been identified as a safety issue, recently override the 1-year statute? I don't think so in any way. We're going to touch upon that. We're going to get to that. Okay. Can you just prohibit animals? Yeah, absolutely. But you have to do it by declaration, and you're still going to get FHA dogs, and you're still going to get ADA dogs. Can you restrict where animals go? Yes. And most of the time, you can put some restrictions, like you can say there's a dog waste area, and even FHA dogs and ADA dogs are required to go use the dog waste areas, unless the handler is physically unable to get the dog there. That's the only time. So like you can require a dog be on leash, even if it's an emotional support animal, unless the person physically can't hold the leash. Okay. Parking, you know, I don't know if this were a single family community that we could even fix this right now, because in Colorado, we can't do anything about the car on the street. Now the car in the driveway, that's partially on the grass, you could probably cite it if you have prohibitions against parking on the landscaping. The extra cars, the one with the hood up and the blue one that look like they're parked in the grass, I think you could cite for parking on the lot. But again, what if this is just how they park each night and each morning they all take off for work? You're going to have the same problem with a 3-day issue. It's not a safety issue. It's not a issue. This is, you know, something that you may have no ability to deal with. And that's one of those things that boards don't like to hear, but there's not much you can do with this. What about cats? Can you have a violation for a cat off leash? Well, if that's what the rule is, yes, you'd have to have a rule. I had a community that prohibited any animal. Didn't matter if it was a cat, dog, or anything. Whatever you had to be on a leash. So, you know, again, but if there's a cat running around trying to figure out who's it at, I'm right there with you, Pamela. There's no way you're going to figure out who owns the cat. I think you're completely correct in that one. It's one of those things that people oftentimes let their cats just roam, and they do whatever they're going to do wherever they're going to do it, and you're never going to be able to figure out whose it is. And if you can't figure out who it is, you're not going to get to a fine stage on that one either. On the pool rules, again, these are all obviously short in nature. But these are ones where, again, running at the pool, I think, is great grounds to be suspended, because that has the highest level of liability for the HOA. Because when they're running, if they slip and they hit their head, they can fall in the pool and drown. They can, get a gash from the cement there, whatever. That's absolutely one that I think is appropriate for suspension. Glass at the pool. That one, I think the best one you can use for that is look to your governing documents, see if you have an ability to charge back. Post-Kiowa communities have that ability to charge back, because glass at a pool is not only going to be misconduct, it's going to be an expense, because if that glass gets into the pool, you're going to have to drain the pool, get the glass out, and then refill the pool at a huge expense. You want to be able to bill that back to your homeowners. Work with your whoever your attorney is and make sure that you have got something in place to bill it back, because that's the thing that, again, we're not going to get to fine stage. We're not going to get to it happened, it's done, it's over with. Let's deal with the fact that we want to make that expense the person who appropriately should bear that expense. Jumping the pool gate is obviously, that makes it a trespass, and definitely grounds for suspension if you can do it. Again, you've got to have it in the declaration and then follow it up with the rules. Bringing too many people to the pool, that might be a cost. That might be something, if you're overwhelming the pool because of the people being brought and you can track who's coming in, that might be something that you want to send that expense back, because you had to have more chlorine, you had to have extra cleaning done, you had to have whatever happened. Because of that, you want to try and push that expense back. Vandalism, again, that is something that would be absolute grounds to kick them out, and you want to then get that cost back. Can you prohibit RV parking or trailer parking? That's going to depend on your governing documents. It's going to depend on where they're parking. If they're in the street, you're stuck with the statute, like the car parking. If it's on the lot and it's sitting there, you might even get to the 30 days. So that one we might be able to get to fine on. Short-term rentals obviously are a problem, because what they're doing, again, it's rarely going to be more than 2-3 days. Maybe it might be a week, and we're going to have all kinds of problems. Obviously, it worsens everything. And because of all these problems that come up with short-term rental, that's a benefit to us in a certain way. The benefit is the cities and counties don't like it either, right? The cities and counties aren't getting the fees that they would have gotten out of a hotel. They're not getting, they have worse housing shortage in the counties, because instead of having long-term rentals available for people who want them, everybody's doing short-term to try and make more money. Well, that shortens the housing. So now you have less houses available, and that causes problems. Obviously, you have too many cars parked at units. Oftentimes with this situation, you have, if it's in a condo building, you might have more maintenance because of people banging their suitcases in and out as they come in and out and not carrying. That doesn't even deal with the fact that you've got more people, you've got more trash, and you have your codes to the building given out to how many people, right? What we want to do with this is think about, how do we make this a landlord's problem, right? Because we want to make it so that we can enforce it. Well, if it's 3 days, there's no way we're going to get a letter out, right? Okay, so let's make the conduct something that lasts more than 3 days. What lasts more than 3 days? The listing. The listing's going to be there constantly. So if you prohibit short-term rentals, adopt a rule, work with your attorney, adopt a rule that will go in there and make it that the listing is a violation. That's going to be there more than 30 days. That's going to be something you can hit fine stage. That's something you can go ahead and probably get to 60 days and turn over to a lawyer and go to court on. Okay, so use the things that you can do, right? Here's something else that is a health and safety issue of short-term rentals. They're giving that code out constantly, right? So how many people now have that code? How often do you guys need to then redo your codes in your building? What's the expense of redoing the codes in the building, because the code's been given out so many times by the short-term rentals? If you can tie the code to one person giving it out, right? Now this is a proof issue. You've got to be able to tie, you've got to be able to get the breadcrumbs down there that you can lead that court to prove that this one owner gave out the code so many times, we now have to recode the building, and that expense of $2,000 should be his, right? If you can make that case, again, you've just put an expense onto the person it should be on, and you'll use that expense to try and stop him from the short-term rentals. And so use the things that you can do. Again, you've got to have in your governing documents that ability to somehow push those costs over. Now, if you're pre-Kiowa, you may need to do an amendment. If you're not pre-Kiowa, you're post-Kiowa, and you can track it. Again, you've got to be able to do it. We've had cases where we could very clearly show how the codes were going out, where they were going out, and what was happening. And so we were able to make that happen, okay? But make sure you've got to have it state that. Remember, your short-term rentals only is if your documents say no short-term rentals, because the cases, and they're in your handout, show that the different provisions in Colorado have been looked at, and if it doesn't specifically say short-term rentals are a violation, you're not going to get there using your single-family home language. You're not going to get there using the no businesses, okay? So again, think about amending. Statute of limitations. I know I'm past 1 o'clock, but we're going to keep going so I can get through this for you guys. There are 2 statutes of limitations out there, all right? So it doesn't matter if you're pre-Kiowa or post-Kiowa. It doesn't matter if you're non-Kiowa. There is a 1-year statute of limitations, okay? The first statute of limitations, this one's Kiowa, and it sets forth, notwithstanding any law to the contrary, no action shall be commenced or maintained to enforce the terms of a building restriction, right? Doesn't matter if it was a safety issue, doesn't matter what's going on. If you don't take action, unless action is commenced within 1 year from the date, you're not taking action, right? That means absolutely you either do something or it's gone, okay? And you will see the second provision, maybe. Hello. Well, hopefully it's in your handout because it won't let me turn the page. The second provision says the same thing. Now, what you need to remember on this is what's a building restriction? Hasn't been defined by the courts, so we go with the court orders and court cases we've all had. So anything that they have built, that pergola they built, the porch they built, they painted their house, they took action, right? If any of those things happened, then you have to make sure that, in fact, you clock it, right? It happened on the 5th of January. You got until the 5th of, or the 4th of January next year to file your lawsuit, because the action that is taken must be a lawsuit. You must file a lawsuit. A hearing doesn't extend it, a lien doesn't extend it, a letter doesn't extend it. If you don't take action, file that lawsuit within 1 year, you cannot take action. I frequently have board members tell me, well, what if I didn't see it, so I didn't know? Understand that when you're enforcing covenants, the first thing you have to prove in court is the harm that the violation did to the community. If you tell the court how you couldn't see it for a year, how much harm did it create? You've just lost the rest of the case. You might get to be beyond statute of limitations if you just proved it didn't create a harm. So saying I didn't see it, therefore the clock can't start ticking, that doesn't work. What about what time does the clock start if they're building a home, right? When they start building it contrary to what was approved. So if you gave them approval to start digging in, and they're starting to dig, and the foundation's what was approved, and it's fine, and they were given a approval to do a 1-story house, and now you start seeing a 2nd story go up. The date you start seeing, the risers and the things go up to show it's a 2nd story, that's the date your 1 year starts, because that's the date they're no longer building according to their plan, and they are in violation. So you need to make sure that that's when your clock. Does it matter if they did submit or didn't submit to the 1 year statute of limitations? No. When they start building without approval, that 1 year starts ticking. You don't get extra time because they didn't submit plans. You need to make sure that, in fact, what if they built on the neighbor's yard? Well, I don't care if it's on the neighbor's yard. That's your neighbor's job to file suit on, but that's trespass. And trespass continues until it's adverse possession, and that's 18 years. So that's a different story. How does renter registration impact short-term rentals? I have no idea. What about if there's a garden planted by a resident, not the association? Well, if it's in your common area and they planted it there, you control the common area, go rip it out. It's your common area. So, I mean, there's nothing that says that they can, you know, have it there, then they don't have approval to have it there. I think that's all the questions I have, guys. I can't scroll to the end to point out that it says, you know, all my contact information, but obviously I'm here at Altitude. So if you have questions, let me know. Thank you very much for all of your time and sticking with me, even though I did go a little late. Oh, wait, I have another. Would it be okay to reach out to an owner outside of a violation to try and help? I don't know how you're going to try and help. I mean, you certainly want to talk to them. Or again, I recommend emailing, not talking, because I think that you need to have a record. But you don't want to do something. You don't want to promise something you can't do. So, you know, saying, hi, I want to help, I want to do something, that's nice, but you might not have the ability. I can tell you there's some communities that I know that partner with local churches. And so when they have circumstances where, like, you have an elderly person who can't keep up, is having problems with things, and they want to help, you can refer them over to the helping person, right? So like we have, you know, elderly and they can't paint their house, but their house needs painted. That community has partnered with the church and they connect the person to the church. You don't want to promise the HOA is going to fix it. You don't want to promise the HOA can help them fix it, because that's not what HOAs do, and you don't want to promise that kind of thing. But setting them up and connecting them with another organization, that'd be great. You know, but you got to be consistent. You got to try and connect everybody to that, you know. I think that's everything. So I think we're good. Everybody, thanks for joining us, and we're going to end.